King's University College Faculty of Law and the University of Cape Coast Faculty of Law. The University of Cape Coast is represented by
Koya Abrinobo Mercy
and
Erasmus Papa Akote Kote.
thank you. And the King's University is represented by
Maxwell Adaekwisi.
thank you.
Ogundari Olayinka Valentine.
Thank you very much. And the Law Challenge is brought to you by the kind sponsorship of Goyle, Good Energy, Sun Lodge Hotel, an experience worth repeating, Ghana Revenue Service, Logistics Movers, we move you there. Joy Blossom Ventures, drink fresh, live good, amazing jewelry. GCB Bank PLC, your bank for life. JoyNews, that's your most credible and reliable TV news channel, and Voltic, naturally. Now, in the contest between the King's University College and UCC faculties of law, which is the 7th in the contest, this is the semi-finals. We are going straight to round 1, which is the general round. 5 questions. You have 30 seconds to attempt an answer. And there are only 2 attempts that you're allowed. A correct answer will give you 3 marks. But if you're unable to answer correctly, the question will be passed on for a bonus mark of 1. And that one will be done within 15 seconds and for only 1 attempt. Ladies and gentlemen, if you are ready, let's get into the questions now. And as always, I am just opening the questions as handed me. So let's begin with the King's University College Faculty of Law. One of the functions of the Commission on Human Rights and Administrative Justice, SHRAJ, is to investigate complaints of violations of fundamental rights and freedoms, injustice, corruption, abuse of power, and unfair treatment of any person by a public officer in the exercise of his official duties. Please state 2 special powers of SHRAJ as provided in the Constitution 1992, Article 219, Clause 1. Specificity, Clause 1. Yes.
All right, so the church has the power to subpoena a person to appear before him to give witness. Then they also have the power to cause the production of documents.
And that is correct. A round of applause for him for that great rendition of the answer. SHRAJ has the power to issue subpoenas requiring the attendance of any person before the commission and the production of any document or record relevant to any investigation by the commission. They have the power to cause any person contemptuous of any such subpoena to be prosecuted before a court of competent jurisdiction. They have the power to question any person in respect of any subject matter under investigation before the commission, and they have the power to require any person to disclose truthfully and frankly any information within their knowledge relevant to any investigations by the commission. Now to you, the UCC Faculty of Law. States any 2 functions, not of SHRAJ, but of the General Legal Counsel, the dreaded body in the practice of law and legal education in Ghana, a group that has the subgroup that some people have nicknamed the Sahindrin.
Okay, so the General Legal Counsel regulates the conduct of lawyers or those in the legal practice, and then they also conduct or regulate legal education in Ghana.
And that is correct. Thank you very much. The General Legal Counsel is responsible for the organization of legal education, upholding standards of professional conduct, They appoint the Director of Legal Education, presently run by a good friend of mine. And they also are responsible for the enrollment of lawyers to practice in Ghana. But I have just heard recently that when you are dealing with the law school, deal with it in terms of the examinations that is conducted as if it is your SSS, or is it the senior high school, where the exams are conducted by WAEC. So if there is anything, don't blame the General Legal Council. Don't blame the law school. Blame the examination body. All right. Now, to you, the King's University College Faculty of Law. The procedure for civil litigation in the High Courts of Ghana, and of course in the Circuit Courts of Ghana, is governed by which rule of procedure? What is the name of that rule of procedure, rules of procedure?
The civil procedure, that is the CI 47.
I'll give it to you. The High Court Civil Procedure Rules, 2004, CI 47. Thank you very much. Now to you, UCC Faculty of Law. I want to commence a legal action. I want to initiate a legal action in civil proceedings in Ghana. Tell me 3 ways by which I can commence civil proceedings in Ghana.
Okay, so civil proceedings can be commenced by way of petition, by way of writ of summons, by way of application, originating notice on motion or application.
And that's absolutely correct. That's absolutely correct. You almost got yourself into trouble by simply saying application. Originating notice of motion. Now to you, King's University College Faculty of Law. In the course of this competition, we have met equity very many times. We have met equity as a darling, and we have met equity in many phases. Equity intervenes to relieve parties to a contract of the effect of mistake by the remedy of rectification. Please state 2 conditions that must be satisfied before the remedy of rectification will be available.
We have legal issue, then prior common intention.
Legal issue and
Prior common intention.
and prior common intention. I wish you could be as extensive as you could.
Okay, so we also have the disparity between the previous agreement and the written document.
Thank you very much, and I'll award you the full marks for it. There must be legal issue between the parties as to their right under the contract, and there must be some outward expression of accord or agreement on the terms up to the execution of the written contract. That is prior common intention. There must be a literal disparity between the terms of the prior oral agreement and those of the written documents. It is generally available only where mistake is shared by both parties. That is common mistake. So I ask you for 2. You attempted 3, but I needed you to be more explanatory and not just simply telling me about legal issues and then prior common intention, and as well as the question of disparity. But I will award you the full marks for your answer. Now to you, UCC, Faculty of Law. Discharge of contract refers to the circumstances in which the contract is brought to an end. States 3 ways in which a contract may be discharged, brought to an end.
Okay, so we have discharge by frustration, by agreement, and then by breach.
That is correct. A round of applause for her. That is correct, and that is comprehensive. A contract may be discharged by agreement, performance, breach, and frustration. Now to you, King's University College Faculty of Law. I like to know 3 elements in passing off.
So there must be a misrepresentation, then goodwill, and that the person has actually caused damage to other parties' goodwill or business.
Once again, you are correct, but I need you to try to be expansive in the delivery of your answer.
So the party must have misrepresented the other party's business or goodwill to the public, and it must have caused damage or damages to the other party.
Thank you very much, but I'll still give you 2.5 instead of all the 3 points. You mentioned goodwill. That's correct. Goodwill or reputation attached to the person's goods or services. And in the manner that you describe it, there must be a misrepresentation by the defendant to the public, likely to induce them to believe that the goods or services offered by him are those of the plaintiff or the other party. It is important to state that the party involved here has suffered a loss. You spoke about damage. But why is the loss suffered? Due to the belief that the defendant's goods are those of the plaintiff. Now to you, UCC Faculty of Law, mention the main elements of deceit. The main elements of deceit.
Okay, deceit in thought arises where a person has misled another party into, or had made a statement that, or misstatement that sought to mislead the other party, and that other party had relied on that statement and had relied on that statement to induce him, and has acted in a way that he ordinarily would not have acted in that circumstance.
And the result will be? Thank you very much. I think you have done substantially well. The defendant must have made a fraudulent representation. He must intend that the plaintiff act or fail to act on the representation. But more importantly, the plaintiff must suffer damage as a result of his reliance. You spoke about the reliance on the representation. I will give you 2.5 of the full marks, not the full marks. Now to you, King's University College. How do you differentiate between recklessness and negligence in criminal law?
So for recklessness, the person embarks on doing an act which he does not take the due care, or he does not have the proper skill to take that particular act. But for recklessness, the person foresees a risk, but then he deliberately goes on to take that particular act.
Thank you very much. A round of applause for him. In recklessness, we are talking about a state of mind where the person deliberately and unjustifiably pursues a course of action while consciously disregarding any risks flowing from such an action. But negligence, on the other hand, we are talking about a voluntary act done without the skill and care, and he used those specific words that are reasonably necessary under the circumstance. Now to you, UCC Faculty of Law, mention 3 features, main features of constitutionalism. 3 main features.
Separation of powers, rule of law, and then constitutional supremacy.
And I will give that to you. Thank you very much. A round of applause for her. There must be separation of powers. We're talking about checks and balances. There must be rule of law. Of course, that will go with an independent judiciary. There must be responsible and accountable governance and popular sovereignty. You're talking about supremacy of the law as well. Thank you very much. And on that note, we come to the end of the first round in this contest between the King's University College Faculty of Law and the University of Cape Coast Faculty of Law. A round of applause for our contestants. And at the end of the first round of this contest between UCC and King's University College Faculties of Law, what happened the other day is repeating itself. They begin on equal marks. UCC has 14.5%, whilst King's College also has 14.5%. A round of applause for them. Now, ladies and gentlemen, let's get ready for the second round of this contest, and this is the buzzer round. We're still talking criminal law, contract tort, and legal systems, but here you have 6 questions, and in this round, all you are required to do is to press the buzzer. You are given 30 seconds to tell me who the statements I make represents. If you answer correctly, you get 3 marks. But for every incorrect answer, you will lose 1 mark from your previous mark or the marks gained already. There will be only 1 attempt in this round. The buzzer for the UCC sounds like this. And that for King's University, thank you very much. And beginning with all of you at the same time, really. So here is our very first statement. And one of the exceptions to the general rule that money paid and property transferred, University of Cape Coast Faculty of Law.
Money paid to a minor or property that has been transferred to another person can only be traced if it is a contract or is in relation to, or the minor had used some in procurement of items that are of necessaries.
You had also pressed your buzzer. Should I continue? I am one of the exceptions to the general rule that money paid and property transferred under an illegal contract are irrevocable. I apply where money has been or property has been transferred for an illegal purpose which has not yet been performed, and the plaintiff changes his mind and withdraws from the contract. A party to a contract, despite its illegality, is allowed an opportunity to repent or change his mind and may be allowed to recover any money or property transferred under the contract, provided he begins proceedings before the illegal purpose has been performed either in whole or in part. Who am I? Of course, you have only one attempt and you have lost it. Am locus poenitentiae. Now to our second statement. Please listen carefully. Don't hurry too much to waste your votes. I'm a common law doctrine, and I stipulate that only parties to the contract are bound by it. Yes, King's University College.
Privity of contract.
And that is correct. Privity of contract. Only parties to the contract are bound by it and are able to enforce the contractual obligations under the contract. I believe that a contract cannot confer rights or impose obligations arising under it on any person except the parties to it. I am privity of contract. Now to the third statement. I am found in thoughts, and I am described as a situation where a servant makes a major detour, UCC,
Frolic of your own.
frolic of your own or his own. Now to our fourth statement, and this will be a very short one, so pay particular attention. I involve the issuing of threats of violence, exhibiting, yes, King's
Duress.
University. Sorry?
Duress.
That is incorrect. I'll continue to read. You had also pressed, yes. I heard your buzzer.
But the first one you continued.
I heard your buzzer. I heard your buzzer. All right, so I involve the issuing of threats of violence, exhibiting an intention to execute the threats, coupled with the ability to carry the threats into execution. Since you have all exhausted your opportunity, but you know who I am?
Assault.
I am assault. That's correct. But unfortunately, that will be non-scoring. Please, to the fifth statement, and pay attention once again. It's a brief one. I am a rule which states that for the accused to be liable, death must have occurred within a year. Yes, UCC.
1 and a year.
A year and a day rule.
That is correct. A year and a day rule. Death must have occurred within a year and a day of the accused act or conduct. The law challenge. Now, ladies and gentlemen, here is our very final statement. I am a term in land law where the lessee parts with the residue of the unexpired term. Yes, UCC.
Assignment.
That is correct. Assignments. Where the lessee parts with the residue of the unexpired term of his lease. I am assignment. Thank you very much. The law challenge. And at the end of the second round of this competition between the UCC and King's University College faculties of law, the UCC has 7 points as against King's College 1 point. A round of applause for our contestants. The law challenge. Now we come to the third round, which is the profound quotes round, an identification of a personality in the legal fraternity. There'll be 3 major questions for each of you, and all you are required to do is identify the personality behind a particular quotation and maybe also the case in which the quotation emanates. You have 30 seconds to do that. You have 10 marks if you get it correct. If you are partially correct, you get 5 points for that. There will be 2 attempts at each question. There's no negative marking here. And in the end, we will also require you to identify one personality in the legal fraternity. This is the non-transferable round. I begin this time with the King's University College Faculty of Law. And here is your quotation. Who is speaking and in which case? Article 14, Clause 7 of the 1992 Constitution provides an extra layer of protection to personal liberty, consolidating the guaranteed fundamental human right to liberty enshrined in Article 14, Clause 1 of the 1992 Constitution. Who is speaking and in which case?
Martin Pebu versus Attorney General Bamford Addo.
That's incorrect. And Bamford Addo had long left before Martin Pebu's series of cases were mounted at the Supreme Court. You've been bailed out. Did you have an idea? You didn't. That is Wood CJ. Georgina Wood in Saba versus the Republic, 2015. Now to you, UCC Faculty of Law. Which judge made this observation in which case? Any attempt to construe the provisions of the Constitution 1992 must perforce start with an awareness that a constitutional instrument is a document sui generis to be interpreted according to principles suitable to its peculiar character and not necessarily according to the ordinary rules and presumptions of statutory interpretation. Who is speaking and in which case?
Kunyanya v. Acha, Francois JSC.
And that is correct. That is correct. Francois JSC in Kwenyanya versus Archer. Now to you, King's University College, Faculty of Law. A judge gave this opinion or statement in a famous case. Tell us who this judge is and which case is in contention. In interpreting the Constitution, care must be taken to ensure that all the provisions work together as parts of a functioning whole. And that is your clue. Care must be taken to ensure that all the provisions work together as parts of a functioning whole. The parts must fit together to form a rational, internally consistent framework. Who is speaking and in which case?
Republic versus Fast Track High Court.
You said Republic versus Fast Track High Court?
Ex parte Daniel.
Ex parte Daniel. Uh-huh. It's incorrect, the first place.
High Court ex parte Aji.
It's incorrect. That was your second attempt. Exhausted. You have any idea?
Not too sure, but we're thinking Aqua in National Media Commission.
And that is correct. Justice Sakwa in National Media Commission versus Attorney General. Now to your question. Who is speaking and in which case? Admittedly, the use of the word shall in Article 12.1 imposes an obligation to observe all human rights provisions, but only as provided under the Constitution and not otherwise. Reading Article 14.7 alongside the mandatory Article 12.1 does not confer jurisdiction on any court to substitute shall with may in Article 14.7 in order to give it a meaning clearly different from what the framers intended, an act which would have amounted to judicial legislation, not judicial interpretation. Who is talking and in which case?
Asante versus the Republic.
Incorrect.
Saba versus the Republic.
Correct.
And the judges would again.
And that is correct. That is Her Ladyship Justice Georgina Theodora Wood, Mrs. in Saba versus the Republic, a case that came up just a while ago. Now let's return to the King's University College. Who is rendering this opinion and in which case? The clear thinking of this court is that our supervisory jurisdiction under Article 132 of the 1992 Constitution should be exercised only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to jurisdiction or are so plain as to make the impugned decision a complete nullity. Who is speaking and in which case?
Any idea? Professor Kluje in Asari versus Attorney General.
That's incorrect. There's no negative scoring. You can make the attempts. You've been bailed out. Ladies and gentlemen, we are still talking about the CJ, Justice Georgina Theodora Wood, as she then was in Republic versus Court of Appeal ex parte Chachu Chikata, the legal luminary. Now to the very final one, and that's your question. Who is speaking and in which case? We have the duty and the right and the power to ensure that the provisions of the Constitution 1992 are observed. Period. Period is not part of the quotation.
Yes, sir.
Yes. We have the duty and the right and the power. And that is your clue. Which judge was speaking in which case with such emphasis, combining such words of power? We have the duty and the right and the power to ensure that the provisions of the 1992 Constitution are observed.
We'll go for Archer in MPP VAG.
It's not Archer, but it is definitely NPP versus AG.
Akins.
We shall not be in the business of guessing. Well, you have exhausted your 2 attempts, so you make a partial mark of 5. A round of applause for them. Amwa Sechi, JSC in MPP versus the Attorney General. Ladies and gentlemen, now please fix your gaze on the screen in front of you. And we shall begin with the King's University College. Whose image is this?
Any Yabwa JSC.
Justice Enin Yeboah. He is the Chief Justice of the Republic of Ghana. Justice Kwesi Enin Yeboah, His Lordship. A round of applause for King's University College. Now to you, UCC Faculty of Law.
Henrietta Mensah Bonsu.
That is correct. Justice Henrietta Mensah Bonsu. Joy Abena Mensah Bonsu. Thank you very much. And on that note, we draw the curtain on the third round of this competition. A round of applause for our contestants. Ladies and gentlemen, at the end of the third round of the competition, the contest between UCC and King's University College, the UCC made 35 points as against King's University College 10 points. A round of applause for our contestants once again. Now we shall proceed to the fourth and final round of this contest between the King's University College Faculty of Law and the University of Cape Coast Faculty of Law. This is the rapid fire round. Who will be the captain for the UCC? Erasmus, thank you. And for King's University College?
Valentine.
Thank you, Valentine. Now we shall begin with the UCC. You have 120 seconds within which to answer yes or no, true or false, to 10 questions for 3 marks each. Here we go. According to Section 252 of Act 25, where a contract of sale often entered into between a manufacturer and wholesaler contains a provision which binds the wholesaler as well as retailers who buy from the wholesaler, the third parties, not to sell the product below a certain fixed price. The manufacturer will not be entitled to sue any third party retailer who sells the goods in breach of that resale price mechanism clause in the contract, which he, the third party retailer, is not a party. Is this true or false?
True.
That is true. If a representee, after having discovered the misrepresentation, especially declares his intention to proceed with the contract or does an act from which such an intention can be implied, he will be deemed to have affirmed the contract and cannot thereafter rescind the contract. True or false?
True.
That's true. Special damages cover losses which arise naturally, that is, in the usual course of things, from the breach of contract itself. True or false?
False.
That's false. Under Section 9 of the Contracts Act 1960, a promise to perform a pre-existing public duty constitutes sufficient consideration. This was affirmed in the case of Kessie versus Shaman. True or false?
True.
That is true. Duress is an equitable principle, and undue influence is a common law doctrine. True or false?
False.
That's false. Ratification occurs when a party by his words or conduct demonstrates that he does not intend to perform his obligation under the contract. True or false?
False.
That's false. An event which causes serious inconvenience, hardship, financial loss, or even delay in the performance of the obligation under a contract is sufficient to constitute frustration of the contract. True or false?
False.
That is false. A person who intentionally causes an involuntary agent to cause an event shall be deemed not to have caused the event. True or false?
False.
That is false. According to the Criminal and Other Offences Act 1960, Act 29, Section 84, assaults include assault and battery, assault without actual battery, and imprisonment. True or false?
True.
That's true. And finally, according to Article 117 of the 1992 Constitution, a parliamentarian cannot be served with a civil or criminal process on his way to Parliament. True or false?
True.
That is true. A round of applause for Erasmus Corte, and Mercy Noble Donkor. Now to you, as I try to catch my breath. There were very long sentences in those passages. King's University College Faculty of Law. Your passages are very brief. So here we go. The 1992 Constitution is the supreme law of Ghana and can be found under Article 2. True or false?
False.
That is false. Chapter 2 of the 1992 Constitution deals with the territories of Ghana. That is true. Article 19 of the 1992 Constitution is on fair trial.
True.
That is true. Article 266, Clause 1 states that no interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana a freehold interest in any land in Ghana.
True.
True. Article 266, Clause 4 states that no interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana a leasehold for a term of more than 99 years at any one time.
False.
That's false. The nature of equity was first well captured in the case of Welsh versus Lonsdale. True or false?
True.
False. A claim that borders on an infringement of one's fundamental human rights is to be brought before the Supreme Court.
False.
False. The Criminal Offences Act 1960, Act 29, was first enacted in 1892.
True.
That is true. When an accused person is acquitted and discharged after a criminal trial, this means the accused person cannot be tried again in respect of the same offense.
True.
That is true. Seduction under customary law is when a girl or female under the care of her parents is seduced to leave her parents' home.
False.
True. A round of applause for King's University College. And that was a marvelous performance, if you ask me. You missed 2, right? Thank you very much. And that brings us to the end of this contest. The Lord Challenge. So at the end of the 4th and final round of this semi-final contest between the King's University College Faculty of Law and the UCC Faculty of Law. The UCC made 30 points as against King's University College 24 points. In the final analysis, the King's University College made 49.5 points in total, and the UCC Faculty of Law made 86.5 points. A round of applause for our contestants, and congratulations to you, University of Cape Coast Faculty of Law, Erasmus Corte and Mercy Donkor. That brings us to the end of today's contest. Thank you very much for your company. Catch you again next week.